let's just think about a controversy that exists among those who call themselves textualists. Some textualists say that the statute ought to be interpreted, an ambiguous phrase ought to be interpreted according to the public understanding at the time that the statute was enacted. Other textualists, self-identified textualists, say that a text meaning sometimes only becomes clear over time. So there needs to be an elapse of time. You can consider what's happened in a space of time rightly to interpret an ambiguous phrase. Both camps call themselves textualists. Where do you fit?
In the first one, Senator, I think that an interpretive methodology that allows the meaning of a statute to shift over time, potentially over the course of interpretations by different judges under different circumstances or at the whims of policy or political considerations.
Let's talk about substantive due process for just a moment. What's your understanding of that doctrine?
I think there's a basic test set forth in Supreme Court precedent that I would apply faithfully if I'm fortunate enough to be confirmed, that seeks to identify certain fundamental rights as a matter of substantive due process. That precedent, the precedent for that test, as I understand it, basically requires consideration of whether the right at issue is implicit in the concept of ordered liberty and also consistent with deep history and traditions of the Republic.
Patriots, welcome back to the Patriot Lens. If you love the Constitution, value limited government, and want our judges to actually interpret the law instead of rewriting it from the bench, this episode is for you. Today we're diving into a confirmation hearing that every American should pay attention to. This is one of those rare moments where we get a clear, honest glimpse into the judicial philosophy of someone who could sit on the Third Circuit Court of Appeals. And let me tell you, this nominee, he actually gets it. Now let's break this down. First off, this man was asked a fundamental question. How do you interpret the law when the text is ambiguous? And his response? Refreshing. He said you look at the text itself. You look at the structure of the law. You consider what the legislature meant when they wrote it, at the time they wrote it. Not based on how society feels about it now. Not based on some activist judge's worldview. But based on what the law actually said and meant when it was passed. Folks, that's what it means to be a textualist. That's what it means to respect the rule of law. Right there. That's the key. He said if the text doesn't resolve the ambiguity, his instinct is judicial restraint. He would defer to the legislature. Now compare that to what we've seen in recent years from activist judges on the left. Unelected bureaucrats in robes inventing new rights, new meanings, and rewriting the law to suit their agenda.